Hello, I am Jackie Fox, and welcome to Fox Talks. Today, we're going to be talking about a component of the Mueller report that I see getting misrepresented a lot. And the argument that I want to refute here today is the idea that a crime has to be proven by an investigation, or that an investigation has to demonstrate that a crime is committed, or possibly that someone has to have charges brought against them, or just any variation of the argument that there is some reason that an investigation for the purposes of obstruction of justice is not actually an investigation. So I am going to read from a website that is good for looking up law. It's, I believe, findlaw.com. Pretty good little resource for this kind of thing. But keep in mind, I'm not a lawyer. So the interpretation of this is coming purely from my perspective. But I'm going to show you a little bit of evidence that shows that perhaps I'm not the only person who sees it this way. Elements of an obstruction of justice charge. The elements required for a conviction on an obstruction of justice charge differ slightly by the code section. For example, prosecutors must prove the following elements of a conviction under section 1503 of the federal statute. There was a pending federal judicial proceeding, the defendant knew about the proceeding, and the defendant had corrupt intent to interfere or attempted to interfere with the proceeding. But regardless of the specific section of federal law cited in a particular case, the prosecution need not prove any actual obstruction. The defendant's attempt to obstruct is enough. The element of intent, which is central to such cases, is usually the most difficult to prove, although memos, phone calls, and recorded conversations may be used to establish this. So this also hits on another argument that I've heard for why Donald Trump didn't commit obstruction of justice, and that is he didn't actually stop the investigation. The investigation continued, and as this says, obstruction doesn't, for one, obstruction doesn't mean that you have to have stopped the investigation. Just point number one. But point number two is that it doesn't even have to impede it. You just have to try, and they just have to be able to prove that you tried. So additionally, when we're talking about the specific federal statute that would apply in this case, a defendant can be convicted of obstruction of justice by obstructing a pending proceeding before Congress or a federal administrative agency. A pending proceeding could include an informal investigation by an executive agency. So there is a slightly more minute reading of this that I've seen people reference that said that an investigation doesn't count as a pending proceeding, that pending proceeding would have to mean that there was like criminal proceeding. I mean, not, well, these would kind of be criminal proceedings, but like it would have to be in court, essentially. And that's just not the case. So let's actually look at pretty cool resource here. It's from the Lawfare blog. They did a heat map of the obstruction of justice found within the Mueller report. And I perfectly understand if you haven't read it. And technically, I haven't read it either. I watched a like 10 to 12 hour Vice video where they read it out to me. It took several days because there's only so many hours of Mueller report you can get through at a time. But yeah, I would totally agree with this. There was a good bit of evidence. It was a little bit scattered, and honestly, because of how much space, how big the Mueller report is, and how spread out some of these things could be, it can be a little bit difficult to refute people that say that there's no evidence, because it becomes a pain in the ass of parsing to try to go in and flag all of that evidence at a moment's notice, unless you make a concerted effort to read through all of it with a fine-tooth comb and pick out these pieces, it can be very difficult to cite specific examples. But that's exactly what these guys here have done, and they've made essentially some of the best cases for it. So there's a great graphic here that shows how much evidence they believe that they have, and where it lines up on each of these three axes of there was an obstructive act, there was an obstructive act, there was a nexus, and there was a clear showing of intent. And there are 4 cases out of about 10 or 12 that they list here that had substantial evidence in all 3 of those things. So that's what I'm going to read out to you now. The first one is in the efforts to fire Mueller. So, the obstructive act, which can be found on page 87. Former White House counsel Don McGahn is a credible witness in providing evidence that Trump indeed attempted to fire Mueller. This would qualify as an obstructive act if the firing would naturally obstruct the investigation and any grand jury proceeding that might flow from the inquiry. As for the nexus, which we find on page 89, substantial evidence indicates that at this point Trump was aware that his conduct was under investigation by a federal prosecutor who could present evidence of federal crimes to a grand jury. And then the intent, also found on page 89, indicates that the president's attempts to remove the special counsel were linked to the special counsel's oversight of investigations that involved the president's conduct. Another good example here is the efforts to curtail Mueller. That is our second example. The obstructive act is found on page 97. Trump's effort to force Sessions to confine the investigation to investigating only future election interference would qualify as an obstructive act if it would naturally obstruct the investigation and any grand jury proceedings that would flow from the inquiry. Taken together, the president's directives indicate that Sessions was being instructed to tell the special counsel to end the existing investigation into the president and his campaign. The nexus, also on page 97, at the relevant point, the existence of a grand jury investigation supervised by the special counsel was public knowledge, so he definitely knew. Page 97, we get the intent. Substantive evidence indicates that Trump's efforts were intended to prevent further investigative scrutiny of the president and his campaign's conduct. Let's see what our next one is. Okay, ordering McGahn to deny attempt to fire Mueller and conduct towards Manafort in terms of cooperation. So, okay. Order to McGahn to deny Trump's order to fire Mueller. Obstructive act can be found on page 118. The effort would qualify as an obstructive act if it had the natural tendency to constrain McGahn from testifying truthfully or to undermine his credibility as a potential witness. There is some evidence that Trump genuinely believed press reports that he had ordered McGahn to fire Mueller were wrong. However, other evidence cuts against this understanding of the president's conduct. The special counsel lists a great deal more of evidence on this latter point. The nexus appears on the next page, 119. At this point, the special counsel's use of a grand jury had been further confirmed by the return of several indictments. Mueller's office had indicated to Trump lawyers that it was investigating obstruction, and Trump knew that McGahn had already been interviewed by Mueller on this topic. This evidence indicates the president's awareness that his efforts to fire Mueller were relevant to official proceedings. Trump likely contemplated the ongoing investigation and proceedings arising from it in directing McGahn to create a false record of the earlier interaction. And then one more page later, we get the intent. Substantial evidence indicates that the president acted for the purpose of influencing McGahn's account in order to deflect or prevent further scrutiny of Trump. And okay. So we've got conduct towards Flynn, Manafort, and unknown individual Stone. Possibly. Question mark? So according to Lawfare Blog, the evidence is strongest here against Manafort, but they're lumping all three of them in together because they appear at the same part and same pages within the report. So the obstructive act is found on page 131. The president's actions towards witnesses would qualify as obstructive if they had the natural tendency to prevent particular witnesses from testifying truthfully, or otherwise would have the probable effect of influencing, delaying, or preventing their testimony to law enforcement. Though Trump's lawyers' exchange with Flynn's lawyers could have had the potential to affect Flynn's decision to cooperate, Mueller could not determine whether Trump had any knowledge or involvement in the exchange. Regarding Manafort, however, there is evidence that the president's actions had the potential to influence Manafort's thinking on cooperation, and his public statements had the potential to influence the trial jury. Sorry. Forgot I didn't turn the AC off. Okay. So, we're at the nexus, which comes on the next page, 132. Trump's actions towards all three individuals appear to have been connected to pending or anticipated official proceedings involving each individual. The intent is also on page 132. Evidence concerning the president's intent related to Flynn as a potential witness is inconclusive. Why am I trying to add a whole nother syllable to this word? Okay. But evidence indicates that the president intended to encourage Manafort not to cooperate with the government, though there are alternative explanations for Trump's comments during the Manafort trial. So it seems like to me that at least a couple of those are pretty solid, like on a legal level, but you know, we often think that as non-legal professionals, we often think that cases should be more cut and dry, when really the American system is set up such that we try to give people so much of a benefit of the doubt that sometimes from a layman's perspective, someone can look damned guilty and still not be punished because our system was designed to work that way. There are a lot of cases and a lot of evidence that sometimes it works in the opposite direction, where certain factors about a person can influence a judge to convict a lot more often than perhaps their legal rights would indicate, which is just kind of a vague way of saying that in a lot of cases, the full protections of the way that the U.S. system was intended only really apply to white people, and especially the more privileged of white people. Or celebrities. Celebrities tend to get away with murder. That's my OJ joke for the show. Okay, so while I am just a layman, I want to bring one final thing into this. As of the time of filming this video, 803 former federal prosecutors have signed on to a document, which I'm going to read a bit from. And this document says that if the president weren't president, that he certainly would have been charged in this case. And that, you know, what we've been suspecting as laymen or perhaps news pundits, that the only reason that Mueller didn't file charges was because he believed that he could not indict a president and therefore it would be unfair to charge him. These 803 former federal prosecutors seem to agree with that. So let's look at the statement that all of these guys have signed on to here. It starts by saying that we are former federal prosecutors and we have served under both Republican and Democratic administrations at different levels of the system. As line attorneys, supervisors, special prosecutors, United States attorneys, senior officials of the Department of Justice. And if you can actually look through the list, I'm going to include a link for this, and there is like a full spreadsheet that you can look at, looking at each individual person and seeing I looked through a little bit of the list. Obviously 803 people is a lot, but there seems to be a lot of experience here. Like, apparently this is a job that gets you a pretty long career. A lot of these people worked as federal prosecutors for like 30 to 40 years, if not a little bit more. So very experienced, and people who have worked under Republican and Democratic administrations. It continues, each of us believes that the conduct of Donald Trump described in the special counsel Robert Mueller's report would, in the case of any other person not covered by the OLC policy against indicting a sitting president, would result in multiple felony charges for obstruction of justice. And then they go over some of the points that I was talking about earlier. So this is kind of a good summary of it. The Mueller report describes several acts that satisfy all the elements for an obstruction charge. Conduct that obstructed or attempted to obstruct the truth-finding process, as to which the evidence of corrupt intent and connection to pending proceedings is overwhelming. These include the president's efforts to fire Mueller and falsify information about that effort, the president's effort to limit the scope of Mueller's investigation to exclude his conduct, and the president's effort to prevent witnesses from cooperating with investigators and probing him in his campaign. And then they also go into each one of these points in detail as well. And I would like to point out that those were the same points that I just read to you. So again, while I haven't passed the bar and don't necessarily have the legal chops to tell you exactly what all this means, there are 803 people who are willing to put their names and information behind supporting exactly what I just said. And I'm going to be including a link to this in the description as well as the rest of my sources for this, the ways that, for example, I defined what constitutes obstruction of justice and whether or not an investigation that doesn't go beyond being an investigation is something that can be obstructed. So you can feel free to check my sources and tell me if you feel like I misinterpreted something. If anyone has any legal experience that they want to contribute, just drop it down in the comments. I'd be happy to hear from all of you. And if there's someone out there who thinks that there is another good rebuttal for this or another good reason why perhaps everything that I've said so far doesn't matter, let me know. I would be curious. If nothing else, you're giving me potential follow-up video fodder. So this is just my first look at the Mueller report. I'm going to look a little bit further into it because there was a lot of it that dealt with Russian interference into our election. And I feel like there's a couple of problems with that because, first of all, there's a lot of focus on was obstruction committed. I'm sorry, not obstruction. Was there conspiracy between the Trump campaign and Russia? And we seem to have buried the lead, or at least diminished its importance in our outrage about other things, about how crazy and how in-depth the Russian influence into the election was. But even talking about it like that is doing a great disservice to the fact that it went far beyond our election, that it started far before the election, that it goes on today. and has been linked to all sorts of things that I don't think any of us like. So that's a heavy topic that I'm going to cover in a future video. But in the meantime, that's all I've got for this one. So if you liked it, be sure to give me a like. It really helps the channel out. Subscribe if you want to see more of this stuff. If you want to take more deep dives, want to learn how to rebuke some of these stupid arguments with actual evidence and sources. If you are just coming here to take advantage of my research and copy my sources so that you can make your own arguments from them. If you're a college student who has to write an essay and needs a bunch of citations and a bit of a thesis, I got you. Just enjoy your lives until I see you again.